privacy of sexual assault survivor, and we will go like this. First I will be talking about the MTB Act 2021 and the Honorable Supreme Court judgment regarding this. I will introduce the topic then. Then we will be talking about the landmark cases, law of the land, views of the Honorable Supreme Court, and how we handle sexual assault cases in our institute. The MTB Act 2021, we are going to see about who and when can the pregnancy be terminated. Pregnancy due to failure of contraceptive methods and devices is up to 20 weeks. This does not classify who the woman is. The woman is both married as well as unmarried up till 20 weeks. If there is a contraceptive failure, then pregnancy can be terminated. From 20 to 24 weeks, the MTP rules have given 7 categories of women who can have their pregnancies terminated. Beyond 24 weeks, we only have fetal anomalies as the main reason for termination of pregnancy, and these fetal anomalies can only be diagnosed by a committee that has been constituted for the same by a state government. Whatever state government it is, the government constitutes the committee, and this board or committee will then certify fetal anomalies, and then they can go in for termination of pregnancies. The categories you all know: survivors of sexual assault, rape or incest, which we call as the humanitarian ground; minors; change of marital status during pregnancy. Up till 20 weeks, it was a woman or her partner. After 20 weeks, it is only change in the marital status. That is, whether the woman becomes a widow or she gets divorced. Women with physical disabilities, as per the Disability Act 2016, mentally ill women, including mental retardation. There is a difference between mentally ill women and mental retardation, and the difference has been given in the MTP rules of 2003. And in Chandigarh, we had one case, Suchitra Srivastav. This girl was 18 years old. She was mentally retarded. She wanted to continue the pregnancy. Chandigarh administration, as her caretaker and as her guardian, did not want her to continue the pregnancy. So it approached the court, and the court refused to give permission to Chandigarh administration to have a pregnancy aborted. And it said that a mentally retarded person has the ability to decide whether or not she wants to continue her pregnancy. And therefore, in this case, Suchitra Srivastav versus UT Chandigarh, the woman with mental retardation was given the right to continue the pregnancy till term. So there is a difference between mental retardation and mental illness. Then fetal malformation and women with pregnancy in humanitarian settings, disasters, emergency situations. This is the MTP Act. Now, who can terminate? Up till 9 weeks by medical methods, any RNP with 3 months experience in gynae-obs or who has performed 10 MPs under direct supervision in government hospital. 9 to 12 weeks, 6 months house job is required. 12 to 20 weeks, 1 to 3 years of experience in the field of gynae-obs or an MD in gynae-obs or one degree or diploma. One doctor can decide and same doctor can perform. But beyond 20 weeks, you require 2 doctors to decide as well as to perform. Now comes the main case that we are going to talk about. That is Miss X versus Principal Secretary Health, Government of NCD of Delhi. This judgment has come in 2 parts. The first part was in July 2022 when the Supreme Court requested AIDS New Delhi to form a board and then to get the pregnancy terminated. And in September 2022, it gave its comprehensive judgment and it touched upon a number of cases that we'll talk about. But In the whole judgment, the Honorable Supreme Court talked only about the change of marital status. And now, as per the Honorable Supreme Court, the change of marital status has been changed to change of relationship to include unmarried women who have been separated, deserted or abandoned by their partners. Okay, nothing about failure of contraception or fetal anomaly. It has only talked about one single thing, and it is change in the marital status. Again, for the first time, this court in its judgment recognized the concept of marital rape, and that too only for the sole purposes of MDP. If a female comes to a doctor and says that I have been raped during my marriage and I do not want to continue with this pregnancy, the woman can have her pregnancy terminated. Okay, it also, second important thing is, it also tells you how information is to be given to an RMP by an RMP as mandated by Section 19 of POCSO Act. Now, Section 19 of POCSO Act says that if a doctor has the knowledge or has an apprehension that some sexual offense is to take place, he is to mandatorily report to the police. Now, Rule 3B of the MTP Act says minors also come within the category of women who can terminate their pregnancy up to 24 weeks. We have seen in the rules, the second rule is minors, and minors can go for termination of pregnancy up to 24 weeks. The problem is, as soon as a minor comes to a doctor, he is mandated by the POCSO Act to report to the police. Okay, so two things are contradictory here. If a minor comes, you have to mandatorily report. The court says that because of lack of sexual education, adolescents are unaware of functioning of reproductive systems and the advantage of use of contraceptive devices and methods to prevent pregnancy. And hence, due to consensual sexual relationship, they might become pregnant and get to know about their pregnancy till late in the gestation period. We talked about Rule 19. Failure to report as mandated by Rule 19 is a punishable offence under Section 21 of the Act. So you have to mandatorily report. Now, how do you report? If you report, the adolescent will not come to the doctor. And what else is the option? To go to a quack and thereby increase the chances of her own mortality. So the court says that the POCSO Act, Rule number 19, only tells that you have to give information to the police. It does not say that you have to give or reveal the identity of the victim to the police. So the Honorable Court says both for MTP as well as for conforming to the POCSO Act, you should read both acts harmoniously. So when a girl comes to you for MTP who is less than 18 years of age, you have to report to the police that one minor has come to this hospital for MTP, but you need not give any information whatsoever regarding the identity of the woman. This is what the Act says and what the Supreme Court judgment says. It says the RMP need not disclose the identity and personal details of minor in the information provided under Section 19(1) of the Act. So, you can report, but you don't have to tell the identity of the victim. This is what we do in our hospital also. If a girl comes to us, see, another problem here is when you talk about Section 375 of IPC. Section 375 IPC says that one of the exceptions is a married woman who is above the age of 15 years. But POCSO is absolutely silent regarding this. So if a girl who is married, 17 years of age, comes to the hospital, you have to mandatorily report, even though she is married, because POXO doesn't differentiate between married and unmarried women less than 18 years. But 375 does. So even in 375, if the girl comes to you, though it is not rape as per 375, it does come under POXO. So you have to inform the police. So what the court says is, you inform the police, say that one case of a minor has come to us and we are reporting under MTP, but you don't have to divulge any details. It is for the police to find out. This is again, the RMP who has provided information under section 19(1) of the Act is also exempt from disclosing the minor's identity in any criminal proceeding which may follow from the RMP's report. This would prevent any conflict between the statutory obligation of the RMP to mandatory report under offence, and also you are protecting the right of privacy and reproductive autonomy of the minor under Article 21 of the Constitution of India. So this is how it is to be done when a minor girl comes for MTP. So now let's talk about our main thing. We all know that it is an offence to reveal the identity of a victim of sexual offences, particularly rape, and it is mandatory for us to protect the and respect the privacy and confidentiality of the victim. Honorable Supreme Court in Nipun Saxena and another versus Union of India and others, it has said that in our society, victims of sexual offences, particularly of rape, are treated worse than the perpetrator of the crime. They are ostracized and treated as an untouchable in her own hour of crisis by the society, even by her family, as though she was the one responsible for the loss of the family honor. As per the Honorable Court, even in the police station and courts too, she is not given the dignity and sympathy that she deserves, but is made to feel as though she is the main cause of the crime and that the whole incident is her fault. Further, a minor who is subjected to sexual assault needs to be more protected than an adult victim, because the adult victim may be able to withstand the onslaught and mental harassment meted out by the society, but a minor victim will not be able to do so. Again, in cases of minors, the perpetrator of the sexual offence may be a member of a family or a friend or someone in whom the child has placed trust. Hence, many times efforts are made to hush up the crime. Therefore, confidentiality and privacy of a child should mandatorily be respected and protected by all persons dealing with such cases for its holistic development. Now, all changes in the law have come because of certain landmark incidents. We have the Criminal Law Amendment Act of 1983, which was as a result of Mathura rape case which occurred in 1972. We have the Criminal Amendment Act of 2013, which was because of the Mathura rape case. Then there was another rape, Katua rape case, which brought changes in the CLA. So all these have been done only because of certain incidents which were bad. Mathura was a tribal girl and she was raped by two constables. They were Ganpat and Tukaram in the police station in Maharashtra. The Sessions Court found them not liable because according to the Sessions Court, it was a consensual sexual intercourse. There were no injury marks on her body and Mathura was habituated to sexual intercourse. This was the Sessions Court verdict. The High Court changed it and it gave Ganpat and Tukaram 1 and 5 years of imprisonment respectively. However, when the state government and the police department appealed to the Supreme Court against the High Court's order, then the High Court said, the Supreme Court said, there was no alarm, no visible marks of injury, no struggle, therefore there is no rape. The Honorable Supreme Court also said that as the girl was used to sex, she herself might have incited the cops to have sex with her. This led to an outrage and protest by various women's organizations, legal luminaries, etc. all over the country and forced the government to make radical changes in the law related to sexual offences, and that is when we got the CSA 1983. The most important section that we are going to deal with today is section 228A of the IPC, which was brought in by the CSA 1983. The IPC says that the identity of an alleged victim of offences under 376, 376A to E cannot be printed, published or made public or revealed. They can only be done so by or under the order of an SHO of concerned police station, authorization by the victim in writing, and the victim is dead or of unsound mind or a minor, then written authorization from the next of the kin. The Act also says that no such authorization shall be given by the next of kin to anybody other than the authorities. Now, in the Nirbhaya case, the father of the girl wanted her name to be made public because he wanted her to be made as a martyr. And when we approached the courts refused to give permission because the girl was more than 18 years at the time, but she was completely unconscious and she was not in the position to give consent, and therefore the court said that the fathers cannot do it without on the behalf of the girl. Now, as regards the minors, we have two acts, the POXO and the JJ Act of 2015. According to the POXO, it is mandatory that the right to privacy and confidentiality of a child survivor be protected and respected by every person by all means through all stages of judicial process involving the child. And the law should operate in a manner that the best interest and well-being of the child should be given paramount importance in every stage to ensure its all-round development. Section 23(2) of the Act says that the Act prohibits disclosure of identity of a child survivor. You cannot bring or publish the name, address, photograph, family details, school, neighborhood or any other particulars leading to the disclosure of the identity of the child. Section 24(5) requires police officials to ensure that the identity of the child is protected from media unless directed by special court. Again, Section 33 of the Act says the special court shall ensure that the identity of the child is not disclosed at any time during the course of investigation or of trial. You see that even the Honorable Supreme Court is following its own diktat. The recent judgment of that girl from Manipur in Delhi was given as Miss X versus so and so. Even the Supreme Court in its judgment has not revealed the name of the girl involved in that case. POXO rules say that when emergency care is to be rendered to the survivors, they have to be done in such a way that the identity is not revealed, and the hospital shall not demand any legal document as a prerequisite to providing medical care. All forensic evidence should be collected in accordance with Section 27, and the report should be submitted to the Special Police Unit within 24 hours. Now, the JJ Act Section 74 prohibits the disclosure of the identity of the child. The Act says that no report in any newspaper, magazine, audio-visual media or other forms of communication regarding any inquiry, investigation, judicial procedure shall disclose the name, address, school, any information leading to the identification of the child. This is the same as 228A, but this is for a child who is in conflict with the law. Now, the important mandate of both these legal provisions is none of these provisions regarding revealing the name or identity of the child can be waived by anyone. either the child or the parents of the child. So what does the Honorable Supreme Court say? The most important judgment regarding this is the Nipun Saxena and another versus Union of India and others. This is a 2018 judgment. You can go through this regarding the maintaining privacy of the victim. The court says when the police officers are investigating such cases, they should not use the name of the victim, but they should use a pseudonym to describe the victim unless absolutely necessary. Only a sessions judge, magistrate can order that a copy of the FIR be given to certain people, giving reasons for the same, keeping in view the interest of the victim. Situations where identity of the victim may be disclosed are when samples are to be taken from her body, medical examination is to be conducted, DNA profiling is to be done, date of birth has to establish from school records. In these cases, the identity of the victim needs to be disclosed. But in these cases, police officers have to use caution and disclose as little of the identity of the victim as possible. It also says that authorities to whom the name or identity of the victim is disclosed are duty bound to keep it confidential and not disclose in any manner except in a report which should only be sent in a sealed cover to the investigative agency or to the court. Any document that can be scrutinized by a large group of people should only have pseudonyms. Original documents carrying the name, identity of the victim should be kept in sealed covers. So, identity of the victim to be made private and honored at each and every step of even your medical treatment, medical investigation, etc. If an adult victim has no objection to her name being published or identity being disclosed, and she authorizes the persons in writing to disclose the name, which is completely voluntary act, then it can be disclosed, because some victims are strong enough and willing to face the society even after names are disclosed, and this will help other victims of rape become source of inspiration to other victims. They can also come forward and report the sexual offences. Now, if a dead body of an unknown victim is found and it is established that she was subjected to rape and that it is not possible to identify her, then her photograph needs to be published in newspapers. In such cases, the fact that she was subjected to sexual offense should not be disclosed by publishing the photograph. Whenever identity of a victim needs to be revealed, an application is to be made to the sessions judge or special magistrate, who may authorize the same with reasons keeping in mind the welfare of the victim. Even the dead have dignity and that cannot be denied to them. Now, how do we do this in GMCH? In order to prevent disclosure of identity of the victims, we in GMCH, before this I just wanted to tell you that in GMCH we did one case of a 10.5-year-old girl who came to us in 2017. She was 32 weeks pregnant when she came to us, and she was the first young girl of 10.5 years in this country, and so this became a news all over the world. There was one CWP by in Chandigarh. This was Alok Srivastava versus Union of India, and through this CLP, which the Supreme Court connected to Nipun Saxena versus Union of India, the Honorable Supreme Court used to monitor this case in GMCH throughout the treatment. And our experience that I am going to tell you has come from the various Supreme Court orders that were passed on to us through the legal set authority of Chandigarh. So based on this, we prepared SOPs of how to protect the identity of the victim, and these SOPs are now being followed by our institute for each and every case that comes to the OSCC or the one-stop crisis center. At admission, the emergency medical officer or the casualty medical officer will make an observation file using the pseudonym, that is an X or Y or Z or whatever, without noting any details which can potentially reveal the identity of the survivor. That means if a female has come and we know that this is a case of sexual assault, we will only write Miss X, resident of Chandigarh, resident of Punjab, or resident of Haryana. That's it. We don't note down anything else. This is the only thing that we will note down in the file that is prepared by the EMO. And this X will be there on this file throughout her stay. Now, after taking this file, the survivor will be sent to the OSCC of the institute with an attendant. Treatment, medico-legal examination, relevant investigations, counseling, etc. will be done by the doctor on duty of the Department of Gynae Ops and any other relevant departments. Like if it is a child, pediatrics has to come, anesthetists have to come, counseling, psychiatry department has to come, investigation, radiology department or other departments will be coming. So all this will be done for the girl in OSCC only. She will not go here. The departments will come to her, the doctors will come to her in the OSCC, and all counseling, treatment, investigations will be done. This OSCC is, our OSCC is attached to the Department of Gynae Ops. So if she needs treatment from the OSCC, she will just go to one room where there is a secluded area for her admission and stay during the course of her treatment in our hospital. Now, at OSCC, the senior resident who deals with this case, senior resident from Gynae Ops who deals with the case, will take a copy of identity proof of that survivor. It can be an Aadhaar card, voter ID card, or anything. And if the survivor is a minor or does not at that time have the identity proof, then one of the identity proof of one of the parents is taken. The senior resident will then write that I have verified the photocopy with the original, and she will send a copy of the same sealed cover to the office of Department of Gynae Ops, giving CR number, date and time of registration, pseudonym used at the time of registration with her signature, name and date and time of filling the document. So she will take the identity proof. On that identity proof photocopy, she will verify that she has done this with the original. She will seal this, and on the envelope, she will give the CR number, time of registration, pseudonym that she has used at the time of registration with her signature, name and date and time of filling the documents, and this will be sent to the Department of Gynae Ops. Department of Gynae Ops will have a register where this will be received and will be entered. So, in future, if this girl's any investigations comes, they will look at the date, CR number, and from the register, they will take out that envelope. Through that envelope, we will know which girl we are picking. And then we can do the further investigation or further opinion or whatever procedure we have to do, we will do. Now, since senior residents, junior residents are a turnover population, that means they leave the department very quickly. And number of times they don't sign properly where they are supposed to sign. We have a register in our department, which now even Gynae Ops is having. This register is known as signature and photograph register. Every resident who comes to our department, at that start, we will have that photograph or his photograph, complete address, small initials and complete signature, and when she leaves, he or she leaves, we put down the forwarding address there. So this register is with us, and with this register, we can trace out that resident wherever he or she has now gone. And this register, believe me, will help you a lot if you maintain this register for all your demonstrators. We also have all of faculty in this. So anybody who comes to our department, then he will have his photograph, signature, address, everything. We have an official copy. We even take this register to the course. Suppose we get a case of 2012 and one resident doctor who has joined only recently is dealing with that case. And tomorrow court asks, do you recognize the signature? We say yes, this is the signature that we are recognizing. We even show this to the register of the court. And the courts agree with this. So it is better if you can follow this. Then safe custody of this document, that is the document that the senior has collected, will be the responsibility of the doctor and the department. If the survivor needs admission, file will also be made. Throughout the hospital stay, file will be in the custody of the nursing officer of the ward, given to the doctors for putting notes and prescribing treatment. All investigations will be requested using pseudonym CR number generated by the MRD. Even as per the PCPMDD Act, when we have to send the information to the government, we do so only like this. No department in the hospital will ever ask for any other details of such patient. Nor will preserve any information which has the potential to be used in any way that will lead to the identification of the patient. Even on discharge slip, no identifying data will be mentioned. Sometimes we get patients with vague complaints. Later on we find out that this patient who has come to us with vague complaints is actually pregnant. In such cases, the existing file will be sent back to MRD and a new file with the pseudonym is prepared and both of them are plugged, and all departments where the name of the girl has gone will be asked to strike down the name and put the new pseudonym, give the signature and date of striking of the name. And rest of the procedure will be same that is followed. In case of males, everything is the same. Only one thing here in males is that the documents of identification will be collected and sealed by the EMO instead of the Department of Gynae-Obs, and then be sent to the Department of Forensic Medicine instead of the Department of Gynae-Obs. We have found this protocol to be one of the best possible for almost all situations dealing with a victim of sexual assault and in strict adherence to the various laws mandated by various legislators in India. Thank you.